through that. Thank you.
Thank you, Corey. Our next panelist is John Chisholm, who has been the district attorney in Milwaukee County, Wisconsin since 2006. And my question for you, John, is what are the problems that you see with respect to the delivery of indigent defense services in Milwaukee County? And why, as chief prosecutor for the county, does it matter to you?
Well, thank you very much, Melinda. Thank you, ladies and gentlemen, for attending this matter today. I'm going to first probably disappoint everybody here by immediately agreeing with everything Carlos just said. I mean, that's not what you expect to hear and not what you expect to see. But the reality is that prosecutors and defense bar and public defenders have been working to address the fundamental issue that I see, the crisis that we're confronting is how do we develop a unified vision of public safety, in which all parts of the criminal safety system, and it's not just the criminal justice system, because I would argue that to those three legs of the stool, you ought to add the fourth leg of the chair, which is the Department of Corrections in most states, where most of your costs are currently being sustained by the states. And what I'll argue in closing here is that part of that unified vision of public safety means that we have to develop a system that, in effect, does a reverse mortgage on our correctional system and starts putting some of the enormous costs. Wisconsin's about $1.5 billion a year is tied up in our correctional system. Just for comparison's sake, the entire DA program for the state of Wisconsin is about $40 million. So we're talking about a huge disparity in cost at a time that states, counties, and local municipalities can no longer afford to sustain those costs. So how do we come up with this unified vision of public safety where we keep people safe and we preserve their civil liberties at the same time? You talk about plea blitzes. Plea blitzes are a function of a system that we have created. And what it presumes is that prosecutors and defense attorneys don't talk to each other until the grown-up in the room, a judge, forces their hand and tells them, look, you're out of time, you got to do something with your case. What I would propose to you, one of the fundamental ways we could rethink the system is to have public defenders, defense attorneys, and prosecutors actually talking to each other before a charge is actually issued. Now, everyone understands that in doing that balance between public safety and civil liberties, certain cases are going to be self-evident. In other words, we're probably not going to discuss a diversion or a treatment program for a first-degree intentional homicide or a sexual assault case. We understand that. We can set those aside. The reality is the vast majority of the work we do involves people that are mentally ill, drug addicted, alcohol addicted, are youthful offenders that are making short-term rational but long-term illogical and irrational choices based on all sorts of constraints. So how do we start doing that? And one of the opportunities we have right now, I think, is in these times of great constraint, we're having to rethink how we do that fundamental obligation of preserving safety and still preserving people's individual liberties. And one of the ways we in Wisconsin, we benefit, quite frankly, from a unified court system, a unified public defender system, and a unified prosecution system. But we do not have a unified vision of public safety. We have all of the issues that Carlos mentioned are alive and well in Wisconsin, and we need to, in effect, reverse some of the thinking that we've engaged in for a long period of time. One of the ways I think we can do that is adopting problem-solving approaches, not only within the court system, but outside the court system. Actually linking on policy matters where public defenders and prosecutors can advocate for the same goals while still retaining their proper roles in jurisdictions. When we have to fight, we fight. But on 99% of the issues, we ought to agree. Our chief public defender once categorized all of the work we do in essentially two categories, dealing with people who A, scare us, or B, annoy us. And the vast majority of the work we do is with those people that annoy us, and we've done a fairly ineffective and inefficient and costly response, reactive response, over-relying on the criminal justice system. Finally, I think that in all of these discussions, as part of a unified vision of how we address these issues, we have to really start at the first time that the offender, and what I'm talking about is actually reversing the way we think. Instead of talking about offenses, we have offense-based systems. We have to start talking about offender and victim-based systems, where we do honest, validated risk assessments on individuals, figure out what's bringing them into our system, and do something about it. That's how we're going to keep our community safe. We're just going to recycle the same problem, doing the same thing over and over again. Then we are in big trouble because we can't afford to do it. But one of the things that we have to address is how we deal with families. And quite frankly, what we've discovered is that we, on the prosecution side, will oftentimes be serving and advocating for the children who are in need of protective services, are having their parental rights terminated, things of that nature. They will then graduate into the delinquency system where we are then prosecuting them, and then they eventually evolve into the adult criminal justice system. What we have found, quite frankly, is that the individuals that pose the greatest risk to us have generally come from that system and been served by that system from the time that they were children. I sit on the Homicide Review Commission in Milwaukee. We look extensively at every homicide that occurs in Milwaukee. Here's the most important fact that came out of it, and that is that for every victim of a homicide and every perpetrator of a homicide, each one of them shared the exact same demographics. They came from lives filled with violence, whether it was childhood violence, they were abused, neglected, they were in the delinquency system, and they averaged 12 arrests and 5 or 6 prosecutions before they either committed a homicide or they themselves were the victims of the homicide. All of these were opportunities, in my experience, to do something, not to wait for the police, but for us to all work together. But one thing a defense attorney can do that a prosecutor cannot do, and that is talk to the client the minute they walk in the door. They can talk to them, they can find out what's happening. Prosecutors can't do that. We need that information to make an intelligent decision about what we're going to do with those scarce resources before we just start a person down the road. That's my perspective on it. I think that of those 4 legs of the public safety system, the public defenders, the defense part, the indigent defense arena is absolutely critical. And I would place that first, develop a unified court system, get a unified public defender system, then you can talk about having unified prosecutors. But I put them in those at that order. There's no question that that's the correct thing to do, the right thing to do. That's the way our system ought to function. Thank you.
So our next panelist is Judge Carolyn Tenon, who has served on the Pennsylvania Court of Common Pleas for nearly 30 years. And in fact, before that was a former prosecutor and a former defender. So